Welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're taking a trip up to the Pacific Northwest to talk about the Oregon Supreme Court's recent decision crushing an anti-gun ballot initiative and why it matters.
Coltac is no longer just making suppressor wraps and pouches. They're jumping headfirst into the precision rifle game with products like the Cuddle Bag, the Boss Bag, the Ammo Book, and the Rifle Handle. You pick the colors, they build the gear. And because you're awesome and you watch TGC, they're doing a special discount code for you. TGC10 will get 10% off your entire order over at coltac.com.
Now, before we get into this, let me explain why we're talking about something that didn't actually materialize. Oftentimes, when anti-gun initiatives are brought forth, the language contained in them is challenged by pro-gun advocates because of the inherently vague nature of the wording. We, of course, can't let vague and outlandish anti-gun proposals go unchallenged. However, this results in an unfortunate side effect. We're slowly educating the anti-freedom opposition about how to word their proposals to be most effective and difficult to challenge in court. In regards to Oregon, let's talk about what the issues with the proposed language was and how it may resurface in the future. There were, in fact, two anti-gun ballot initiatives gun owners were facing. IP 44 was an initiative that would have required Oregonians to store firearms in a particular manner. Fortunately for us, the backers of that proposal shelved any attempt to pursue it after legal challenges were brought. IP 43, the one we'll actually be discussing, was subject to a recent Supreme Court decision in Oregon. This initiative was an attempt to get an assault weapons ban on the ballot for a vote. IP 43 proposed a statutory enactment that, had it been approved by voters, would have prohibited the unlawful possession or transfer of an assault weapon or a large capacity magazine. The proposal had limited exceptions for this outright ban, which included a registration scheme. Assault weapons were defined by the things that you've come to expect, but this definition also included conversion kits from which an assault weapon could be assembled if parts are in the possession or under the control of the same person. So that would mean no more build kits for you guys. Had this actually been enacted, any person who already legally possessed an assault weapon or large capacity magazine as defined in the proposal prior to the effective date would have had to 1. Sell the weapon or magazine to a licensed dealer, 2, and this one only pertains to the firearms, surrender it to law enforcement for destruction, remove it from the state, or render it permanently inoperable, or 3, if eligible, register it with the Oregon State Police. It would have also required that anybody who inherits an assault weapon or large capacity magazine after that proposal became effective to comply with those same requirements. However, that option to remove it from the state was no longer an option for those who were inheriting. The initiative was challenged by a number of people due to the misleading wording used in it. The caption or title of it, which would have appeared on the ballot, read, "Prohibits assault weapons defined, large capacity magazines defined, unless registered with state police, criminal penalties." The petitioners challenged the wording, arguing that it would imply individuals could continue to purchase new firearms that would be covered by this proposed statute as long as they were registered with the state police. And as we discussed a moment ago, anything acquired after the effective date, with the exception of a firearm being inherited, would be unlawful. The Oregon Supreme Court agreed, stating that the caption inaccurately describes the registration exception. By stating that assault weapons and large capacity magazines are prohibited unless registered with the state police, the caption implies that the exception generally permits registered ownership after IP 43 goes into effect. And as you can see, that assumption is misleading and untrue. The petitioners also challenged the terms assault weapons and large capacity magazines because they do not reasonably identify the subject matter of IP 43, and instead are impermissibly deceptive, confusing, and under-inclusive. The petitioners argued that people would only perhaps understand the term in reference to things like military-style weapons and their magazines, but not in the context of the wide array of commonly owned firearms that would fit into the definition. They also argued large would imply a number far greater than 10 in terms of capacity, but would regulate magazines that barely exceeded that threshold. The court again agreed that the caption could accurately state that the proposed measure would criminalize the possession and transfer of many semi-automatic weapons, as well as magazines holding over 10 rounds. The petitioners also challenged what would have happened with the yes and no result statements had this thing actually made it to the ballot. Consistent with that determination about the caption, the court ordered the Attorney General modify the yes results as the wording was misleading about the nature of firearms that would be legal if registered. The language in the no statement was also challenged because it implied certain people were barred from purchasing rather than possessing firearms. You know them as prohibited persons. Lastly, the language used in the summary was also challenged. Once again, the summary suffered the same defect as the caption and the result of the yes statement by implying firearms registered would be permissible to possess. The summary also failed to note that the penalty for noncompliance would result in a felony. It just generalized it as criminal penalties, which the court found to be insufficient. Finding a few more defects with that proposed language for the summary, the court referred the ballot proposition back to the Attorney General for modification. So, what does this all mean? Well, in order to collect signatures to get the proposed language on the ballot proposition's language has to be finalized, which as you can see, it's not. The signature deadline is July 6th, and the group supporting the initiative would need to attempt to collect 88,184 signatures in what would be an impossibly small time frame. So for now, Oregon won't be facing a showdown at the polls in November over this proposed ballot initiative. However, we may see it resurface again in the future in some other form. That's it for this episode. If you learned anything from the show, help us out and hit that like button and share it around with your friends. Don't forget to get subscribed, and if you enjoyed the video, consider supporting us via the links down in the video description. If you want to get more out of your TGC subscription, be sure to check out the Gun Collective podcast, which happens live on Thursday evenings. And as always, thanks for watching.
The shirts worn in today's video on the Gun Collective have been provided by Patriot Patch. Closed captions have also been brought to you by Patriot Patch Company. Be sure to click the link in the video description to check out all of their great products, including their cleaning mats.